Good morning, everyone. I'm Claude Barfield, a resident scholar here at the American Enterprise Institute, and I'd like to welcome you to our session this morning. This is based on a new paper that Ted Moran has done, U.S. Government Surveillance Regulations, U.S. Government Surveillance Regulations for IT Company Networks. The background of this paper is that when I first read the draft, and I've done a fair amount of work in this area, the thing that really struck me, the thing that really struck me most was the wide variety of programs that I didn't know anything about that could intervene in terms of government surveillance. This could be my own failing, but I think that most of not only just the public, but policymakers really do not understand, I think, the breadth of these programs and the reach of them. Since then, I think there's a second rationale and that gives the paper a great deal of timeliness in that in several areas, I think 2015 is going to be a key year. Ted in the paper talks about the NSA surveillance, the metadata program. We've had a standoff on that with the USA Freedom Act, which was turned back several weeks ago. In terms of the companies and the war with the U.S. government, that the high-tech companies, Apple and Google have defied, really, the government, the FBI, and others, and produced programs, phones that are encrypted, and so that they will be able to say when the government comes to them, we can't get into the phones. That is a standoff that I think may see some resolution one way or the other this year, though it may not. So there are a variety of things that Ted discusses that I think are going to be important, not just over the long term, but possibly over the short term. So the way we're going to operate this morning is that Ted is going to go through the main parts of his paper, and then we will turn to briefly. Then we will turn to three commentators, and I will introduce them at the time when he finishes. Ted Moran is the holds the Marcus Wallenberg Chair in International Business and Finance at the Georgetown School of Foreign Service. He has published extensively over the last several decades on trade policy and particularly foreign direct investment policy, both outward investment and inward investment. So he's very well qualified to get us started on this. Ted?
Thank you very much, Claude. I wish you would say has published extensively over previous years, not decades. This is, I'm getting a little sensitive to.
I go back more decades, so I'm not going to worry about that. I can match you on that one.
So the U.S. government has 3 or 4 overlapping legal intercept regulations. I'll show you in a minute why I say 3 or 4. That require U.S. and foreign IT operators to deliberately allow U.S. agencies to penetrate their operations. Other governments doubtless have parallel legal intercept regulations. I have tried to look into that, and it's very hard to uncover exactly what kinds of legal, not covert, just open legal intercept regulations there are in other countries. But I want to do more work on that. Now, as Claude said, to prevent discrimination against themselves, many U.S. IT companies and suppliers are arguing that they want a multilateral agreement, an open multilateral agreement among countries to govern lawful requests for data across jurisdictions. So this is not about covert operations. This is about legal intercept. And without such a framework, the worldwide telecommunications market may continue to segment, and I can give some examples of how that is already happening, as governments and private buyers in foreign companies attempt to avoid U.S. government surveillance. So this is a baseline survey of the United States. It's not an expose. All of these regulations are known, But as Claude said, most of the readers of my paper so far, except for the experts on the panel, have been, have found them very extensive and not well understood. So I want to investigate, how do these surveillance programs work and to whom do they apply? To what extent do they apply to the overseas operations of U.S. firms? So this is the extraterritoriality question. To what extent do they apply to foreign firms who enter into the U.S. market? So first set of programs is U.S. government electronic surveillance under the Patriot Act, the FISA Court, Foreign Intelligence Surveillance Court, and the FISA Amendments Act. One section, Section 215 of the Patriot Act, gives the government the ability to issue secret warrants via the FISA court for records and documents that may be relevant, note the word relevant, for a terrorism investigation. The next section, Section 216, authorizes access to online activity and allows the agency that applied for the order to compel any relevant person or entity providing wire or electronic communication service to take part and assist in the surveillance. The request for the warrant and the court's ruling, these are secret and classified. There's no stipulation about the nationality of the providers, so these sections, I conclude, must logically apply to foreign companies operating within the United States. I invite my experts here to comment on that. I think it is true, I think it is accurate, and we want to investigate that. So companies such as Facebook, Microsoft, Google, LinkedIn, and Yahoo have been prohibited from even disclosing the government requests. But last January, President Obama ordered the Justice Department to allow these tech companies to disclose the total number of FISA court orders they receive annually and the total number of users these effects request. Now, you might ask, what is the status of individuals whose records are being investigated? I'm maintaining eye contact because this may well be you. But you won't know about it. Persons whose records are targeted do not have the right to appear before the FISA court, and since the surveillance programs are classified, targeted persons generally have no way of knowing that their records, their library records, their browsing histories, their purchases are the subject of specific government scrutiny. Recall I asked you to look at the word relevant. The FBI need not show probable cause nor even reasonable grounds to believe that the person whose record it seeks is engaged in criminal activity or have any suspicion that the subject of the investigation is a foreign power or agent of a foreign power. I'm pointing this out, again, not in the spirit of expose, but we are going to conclude by talking about the possibility of a multilateral agreement, and we're liable to see this in mirror image coming back at us. So that's why I want to lay out these details explicitly. The second group of legal regulations are FCC, the Federal Communications Commission, Section 214 licenses, and Team Telecom. Any telecommunications provider that offers calling services between the U.S. and foreign points has to obtain a Section 214 certificate, and each Section 214 application that includes 25% direct or indirect foreign ownership is reviewed by Team Telecom to scrutiny for national security or law enforcement or other public interest concerns. A word about Team Telecom, I don't think I included this in the PowerPoint, but Team Telecom draws on the defense and intelligence agencies. Unlike CFIUS, it doesn't have what you might call the more economic agencies. For example, Clay was Assistant Secretary of the Treasury. You would not be a member of Team Telecom. or USTR or the State Department. Depending on the risk level, Team Telecom may impose certain risk mitigation measures. The FCC reports that one of the most common risk mitigation measures is to have the applicant install a repository of all customer data records on U.S. soil, specifically so that this would give U.S. courts jurisdiction over the data for purposes of ordering disclosures. Similarly, Team Telecom may ask the applicant to make a resident U.S. citizen available for service of due process from law enforcement agency if it needs to investigate one of the users. The procedures, investigations, and findings of Team Telecom are not made public, although the security agreements are posted on the FCC. The resulting security agreements are posted on the FCC website. So I said 3 or 4. We've already done 2. The third is the Communications Assistance for Law Enforcement Act, CALEA, that requires all internet and voice, all internet services to become wiretap friendly, requiring companies to deliberately design and manufacture surveillance accessible technologies so that this builds backdoors into all internet communications. Surveillance must be made available on a real-time or near real-time basis and provide continuity of interception as new equipment and software are installed over time. CALEA requires that IT companies that provide encryption services ensure that the U.S. government can decrypt all messages that use encryption services they provide to customers. This is a subject of increasing controversy as Claude alluded to. Finally, CALEA requirements apply to all foreign telecom service providers or switching equipment suppliers operating in the United States. So this applies to China Unicom. It applies to Lucent Alcatel. It applies to Ericsson. The foreign parent firm must know about the requirement to design hardware and software to permit surveillance, but specific requests for intercepts must be made to an appropriately cleared U.S. citizen and kept closely held so that Ericsson or China Unicom would not know about specific requests from the U.S. government. Now we turn to number 4, and this is why I said 3 or 4. This is CFIUS, the Committee on Foreign Investment in the United States. CFIUS is an interagency group led by the Treasury Department. Clay was the Assistant Secretary of the Treasury, whose responsibility is to ensure that acquisitions of U.S. firms by foreigners do not pose a threat to U.S. national security. CFIUS does not have a mandate to require foreign acquisitors to participate in U.S. legal intercept programs per se. That's why I said 3 or 4. This is not directly part of CFIUS's mission, but the committee's mitigation requirements interact with U.S. legal intercept mandates when a foreign acquisition is subject to FCC Section 214 or CALEA requirements. This is an area we may want to talk about. CFIUS does not make its national security determinations public, nor does it provide them on a confidential basis to the parties. CFIUS contends that publishing its national security determinations might reveal sources and methods of U.S. intelligence gathering. As a result, foreign companies do not know what might be held against them and are not able to rebut or defend themselves. There may be, however, and both Nova and Clay can discuss this, a sequence in which CFIUS poses questions or asks for more information that is a little bit of a back and forth without giving away the intelligence gathering methods. Foreign companies have not enjoyed due process as part of the CFIUS investigation, but in the Rawls case, a U.S. court has held that they should be allowed to access to the non-classified portion of the CFIUS determination. Now, simultaneous national security investigations by Team Telecom and CFIUS are found, for example, in the 2013 merger of SoftBank with Sprint Nextel, which in turn was seeking to acquire mobile and fixed broadband provider Clearwire, and together Team Telecom and CFIUS extracted extensive concessions from the parties. First, the Department of Defense, Homeland Security, and Justice secured the right to review and to veto new equipment purchases in certain circumstances. The companies were required to appoint a new Sprint Nextel board member to be approved by the U.S. government to supervise national security compliance. Finally, the U.S. government reserved the right over a period of time to order SoftBank to remove any equipment that was supplied by the Chinese equipment vendor Huawei Technologies. All told, this set the precedent for Team Telecom and CFIUS to control a telecommunication company's management composition and its choice of equipment suppliers. I say this because it is quite intrusive, and again, to build the basis for what we may see other countries requiring at the same time. So many companies are calling for a mutual legal assistance treaty, an MLAT. Gary may be the most knowledgeable member of MLATs, for the purpose of enforcing public laws and preventing criminal or other illegal behavior. They are currently used in countering tax avoidance, money laundering, and terrorist funding activities. Ultimately, the larger goal might be not just to avoid conflict of laws, but to provide, as I say, a multilateral framework for lawful surveillance and national security screening among states. Now, this I am concluding. Such a multilateral agreement would have to allow other governments to follow the same procedures as are now allowed by U.S. regulations. So in other words, others could do to us as we do to them, or would have to require U.S. regulations to be restricted. So we would have to pull back to conform to some as yet undecided, not yet negotiated new international norms. So the question I pose is, are we ready to accept as legitimate that other countries, from Germany, the United Kingdom, France, Japan, and South Korea, to, yes, Russia, India, and China, to set up mirror image surveillance regimes like our own? This is actually a serious question. Would Congress, the U.S. Congress, ratify an international protocol that allows the Chinese government to snoop on Chinese dissidents via Facebook in China and to collect data on democracy activists stored in China Telecom servers in Atlanta, Georgia? That's the kind of mirror image question. Will sober-minded Germans who are legitimately concerned about jihadists coming and going in their midst permit the Federal Republic to sign on to an international surveillance regime that Stasi could only have dreamed of? I say this to point out, I mean, we now have not only Al-Qaeda, but ISIS. I mean, we have real security threats out there. So I want to take both the surveillance question seriously and also the requirements for surveillance clearly and objectively so that we can discuss both sides. Or, finally, will U.S. surveillance regulations have to be scaled back, I just said, despite ongoing threats of international terrorism, and become subject to verifiable limitations? That should end with a question mark. Question mark. Thank you.
Thank you, Ted. I'll go right straight to the panel. I'll start with Clay Lowry, who's Vice President of Rock Creek Global Advisors, which is a global advisory, international economic advisory company. As Ted mentioned, Clay was the Assistant Secretary of the Treasury who was in charge of actually the CFIUS process during the Bush administration. We'll then turn to Nova Daly, who is a professional in international investment and trade policy and has served in the Treasury and Commerce Departments, the White House, and the Senate. And last but not least, Gary Hofbauer, who is the Regional Jones Senior Fellow at the Peterson Institute. I have to say, when Gary's name was suggested, I thought, I didn't know that Gary was involved in any of these things, but apparently, like me, a trade person, he has been dragged into the trade and security nexus. So, at least in my case, and probably in his too, it's been a steep learning curve. Clay, why don't you get us started?
Thank you very much, and thanks, Beatty. I think it's a very important thing that Ted has brought together a lot of information that most people don't understand. By the way, like what? I don't actually know all this stuff. I think there's a few people at DHS, maybe NSA, Justice Department, maybe a couple people in Congress that can understand all the technical authorities. Ted, to his credit, is trying to bring it towards a broader audience. That's a very important thing. He's also touching upon something where there's some very, very significant debates going on. There's a significant debate about national security versus privacy. There's a significant debate about should companies be allowed to create encryption codes in which they can't even break them themselves versus those that are worried about, like the FBI worried about being able to do warrant law enforcement searches. Frankly, if you read the newspaper this morning, you would have seen a huge debate about the methodology that we use in order to try to protect our country. And there's people on all sides of that debate, and it's probably welcome to have a debate. And I think that Ted is, in some respects, opening that kimono up on a lot of other issues. So I was trying to think about where I could be helpful. So I do come from a Treasury Department background with a small stint at National Security Council, almost all of it on the international side. So I basically think about it as how do these issues look internationally? And so Ted's really talked about a lot of domestic laws which can affect international bodies. The one that I know the most about is CFIUS, the one that he gave kind of the 3.5 stars as opposed to a total 4 stars on. And the only thing I'm going to say about it, actually, Nova's going to cover it. Nova knows CFIUS even more than I do. So I'm going to move on to something else. But on CFIUS, the thing to think about is what was CFIUS created for? It was created to try to protect the defense industrial base of our country. That was done in the late 70s and 1980s. Since then, it has evolved over time, and some may even say devolved over time. And part of that comes out of a searing experience in which a Dubai company was trying to buy port operations, which doesn't have anything to do with telecommunications, but it does have something to do with what telecommunications and information technology gets into, which is critical infrastructure and critical technologies that could be important for protecting national security. So that's a lot of what CFIUS is trying to deal with. And Ted tries to make sure that it's understandable for people, but it is a very tricky issue, and the people that work on those systems in the country are trying very hard under very tough circumstances. I actually want to talk about a slightly different issue, which is what is the fallout from this overseas? Ted mentions it at the end about, can you see the mirror image happening to our companies or to our individual citizens abroad, or even just basically, essentially, countries doing that? I think another study that needs to be done is a survey of what other countries actually do on these fronts. I promise you, whatever we do is nothing compared to some of the other countries out there. But a different point is the point that Ted mentioned early on, which is about segmentation. And I think that that's a very important point, and that's what I wanted to talk about. What is segmentation that I'm trying to get at? So segmentation is basically something that is best described as data protectionism. So we have seen that the ability to use, analyze, store, distribute data around the world in a quick, efficient manner helps businesses, improves efficiency, develop new products, deliver goods and services, frankly, helps our lives. This guy's right now working on an iPad, and so that is basically pulling data from different sources around the world, and there are proposals out there from very serious people in very serious countries to basically put walls up to try to protect against that, and a lot of that comes out of the things that Ted was just talking about. And so it's an interesting point, because all these wonderful things that have come from being able to use an iPad like that, or the guy in the back that's got a computer, is there's also been opening up a set of fears. And so these fears have built up on each other. So let me talk about 4 fears that I have heard about. By the way, there's probably about 50, but there's 4 that I can think of. Fear 1, commercial companies are invading our privacy and looking up our data to do certain things with. That is a fear that is out there about what's happening with technology. A second fear is the fear really that CFIUS tries to get after, which is the foreign ownership of data. Now, by the way, that fear in Europe is even worse about the United States type of, not just companies, but now, as Ted's mentioning, about our government. Third is cyber hacking. Basically, that our data is vulnerable to, and I don't mean to put anybody, throw anybody under the bus, but to the Chinese kind of trying to hack into our systems. And then 4 is kind of, and this is really Ted's point, the fear of the government. The fear of the government doing things, and actually I would even just say the fear of data itself, that we have this data. Those fears are, in my opinion, could lead towards very damaging policy implications. And that's kind of what I try to work on. And the one that I've heard about a lot is maybe what we could do to solve this problem, to solve the NSA being able to get at this data, to solve, no offense to them, Google being able to get at this data or what have you, is we'll localize our servers. So we'll store our data, we'll require companies, if they gather data in a country, to store it there. That you will not be able to transmit that data. That you basically have to have data centers there. All right, well, the problem with that is, first of all, if you look at just global economy, it is a total attack on the ability to do commerce overseas. Gary knows these types of statistics better than I do, but if you look at the United States exports, about digitally delivered services as a value add into our exports are 30% of our exports, 30%. In the EU, it's 25%. Okay, so we're going to stop that. We're going to put up these barriers, these false barriers that are going to be controlled by some government entity, which will stop the ability to do these things on a real-time basis. Now, most people, when they think of this, they start thinking about IT companies or maybe telecommunications companies. However, you could make the case that this is actually much more important to financial services companies, auto manufacturers, pharmaceutical companies who have to do health clinic trials, which are extremely complicated and very expensive, and you do that around the world to try to figure out how to make your pharmaceutical drugs better, but we're not going to now allow data to be shared in a real-time basis. It is totally a problem on small to medium enterprises. And the Europeans are actually there's parts of Europe that have actually talked very openly about creating these protectionist measures. At the same time, that the biggest problem that's going on right now in Europe, one of the biggest problems, I shouldn't say the biggest problem, one of the biggest problems is small, medium enterprises cannot seem to grow or get finance. Well, one way of doing that is to be able to interlink abroad. And how do you do that? Today, you do that through internet services. Let me give you an example of agriculture. The ability to use data is revolutionizing how we actually look at agricultural inputs. So to try to find how do we maximize yield techniques, you look at data crop spacing, you look at the data soil, you look at weather patterns. And all the data that is increased, that does this, could improve our ability to grow crops, to improve food security. These are not things that think about. When people think about, well, this is good, very important for data privacy, they think about, well, we got to stop Facebook or we got to stop Google or something. Well, you actually could be stopping an agricultural company, you could be stopping a financial services company, you could be stopping a pharmaceutical or an auto manufacturer. So TED has opened up an interesting point of view about what are the legal authorities that we're using in this country about on surveillance. But then it broadens out into a global economy story that I think is a very important thing for us to think about. So let me just stop there because I've gone on too long, but that's kind of what I wanted to talk about.
That's fine. I have one question of fact.
Sure.
On the one hand, we have the complaints about the localization and with the Europeans taking the lead here and other countries talking about the same thing. And the companies are complaining about that. But on the other hand, you see, and I don't know the extent to which this is happening, but you see again and again in the newspapers that companies on their own are placing servers locally. Mm-hmm. Particularly that's true in Europe. How much is this going to be? Would you solve it that way? Now, there's a different thing about having to keep it local. But I didn't see that that's a part of it. What the Europeans seem to want is that you have to go through a server first in Europe, if I understood it correctly. But if I'm wrong, please tell me, because that juxtaposition has confused me over the last couple of months.
So I actually think that in some respects, companies are making market business decisions. Right. We are trying to explain to our customers that we're going to protect them. We're going to do our best to protect them. And if that means that we have to put a server in Belgium, then we'll put a server in Belgium. But that is a market reaction towards a customer behavior of concern that your customers are showing about you and your products. It's a totally different thing than basically the EU and by the way, this is going on in lots of countries, Brazil, Indonesia, India, China, Turkey, of them basically a government fiat saying you must put this in here, and this is much, because that is when I think you're going to create much more significant problems for yourselves. If it is a commercial reaction to trying to gather confidence from your customer, then I don't really have a problem with that.
Thank you very much, and well, thank you for putting together this paper. I think it brings together a lot of interesting and important national security issues that you actually live with every day and you don't realize you do. I guess before I sort of go through, and what I want to do is just sort of go through the topics you introduced and make commentary on that, but in terms of the 4 fears that CALEA raises, I think those are very important, and they'll have serious economic and commercial considerations going forward, for which Mr. Huffbauer will probably write a good piece, and we will all learn a lot from it. But if you're concerned about foreign governments getting your information, if it's the legal side of it, then that's an important consideration, and I think there's good policy debate that has to happen there. If it's foreign governments getting your information illegally, there's really nothing you can do about it. So unfortunately, our systems are so globalized in terms of the equipment that goes into our communication systems, the details of the programming that happens in our systems, that it's really, at this point, extremely difficult for any government or agency or cybersecurity company out there to really protect you from some of the best actors out there. Nonetheless, I'm going to talk a little bit about the different topics. At Treasury, Clay and I worked together on the CFIUS process. I was his deputy after the scorching debate on Dubai Ports World. We had to reform and fix the process. And one of the big important considerations was you had all this fear that the U.S. government was going to become protectionist and lean towards a closed investment system in the United States. So we had to really make sure we designed the system that we balanced out open investment and national security. And that becomes the key debate also in the FISA issues as well, is how do you make national security a priority, because no one wants to see a 9/11 happen again, but also ensure that you maintain an open investment and an open trading platform in the United States, because one of the keys to our success as a nation over these last 50 years, following World War II, was that we had an open investment and open global trading system. That has brought immense benefits to the United States, and I think the world in whole. Obviously, there are outliers who may not, countries and individuals who may not have benefited, but on a whole, that's been the view of many, that it has benefited the globe. So that was one of the important considerations, and I think that remains a key debate. We have to ensure our national security first, but if we close our open investment process, if we close our free trade abilities, we will eventually squeeze our economic growth. And if we squeeze our economic growth, we aren't going to be able to procure, purchase, and innovate those things that allow us to build our national security. So that's the great balance that's going on, surely in the security world and constantly in the CFIUS area. On the Patriot Act, the FISA courts, it's interesting that we had the sort of the vote in the Senate that didn't allow for a vote of the U.S. Freedom Act. There was strong support on both sides of the aisle for it, and I guess it failed by 2 votes. Which is unfortunate. There are important provisions, Section 215, that will expire in June. They're going to have to be renewed, and if you don't find a way forward on the passage, you're going to get what we've seen many complain about is the dysfunctionality of the U.S. government, and that has broader consequences in terms of U.S. leadership and how we're perceived in terms of a nation. Trust me, when foreign governments look at the dysfunction of our government, whether that be on the administrative level or within Congress or between the both, they see that as a weakness that they're able to exploit in terms of their policy agenda and the issues that they voice globally. So it's important for U.S. leadership that we've solved these issues, especially on this important topic. And we'll see what happens in a new Republican Congress. On the Team Telecom issue, Team Telecom is a very interesting creature, and you'll find very little on it when you Google it. Matter of fact, it's not a creature of law or regulation, nor will you really find it on the FCC website that has it. But it's a very powerful group. Essentially, the FCC, when it grants licenses for communications, if it's a cable landing or if it's a foreign entity that's going to be acquiring that license to provide communications in the United States, Team Telecom reviews it. And it's part of the function of the FCC to look at the public interest test of that acquirer. So the Team Telecom is mostly defense agencies, Homeland Security, FBI, and Department of Defense. But now, recently, I've heard that Commerce and State Department are getting a bigger say on that committee. And the reason why that's the case is because, in many parts, the Snowden leak has put great pressure on what the United States does in terms of its national security and cyber policies. And also that the agreements that Team Telecom forces international carriers and servicers in the United States to comply with is replicated by foreign countries. An interesting case happened with an Indian company that came to the United States and had to go through the Team Telecom and CFIUS process. And there were constraints put upon it in terms of how it could operate, U.S. citizens that it had to be part of its oversight, and especially its network operating center having to be located here in the United States. The Indian government then went and decided, hey, that's a great policy, and instead of doing it for one company or the other company that comes into our country, we're going to do it for all companies, thus leading to the BlackBerry incident there, and also in some respects the UAE. That has implications on our companies, and many are great big multinationals being able to operate and commercially grow abroad. That's no worries. The next issue I'll talk about is CALEA. CALEA is interesting. It's it's the wiretapping to be able to get at criminals. It's our law enforcement people going to the AT&Ts and the Verizons of the world and saying, hey, look, we need to get criminal information on this person. So the requirement in CALEA is really for the providers that go to the end user, but those providers have to be CALEA compliant, meaning any systems or equipment that get put into their infrastructure must be CALEA compliant. That's where the foreign providers of equipment, if it be Huawei, hopefully not, if they should be part of the infrastructure, they have to be CALEA compliant and thus have the aperture for officials to be able to go in there and find information. On CFIUS, I think we've talked about sort of the public face of CFIUS and sort of the business. The one thing I do want to comment on CFIUS is that, CFIUS doesn't publish its decisions, and there's a good reason for it. Because when a company goes through a national security process like CFIUS, and let's say CFIUS doesn't like that company, and they have to evacuate from that investment, well, that could carry a huge commercial consequence, not only for the seller, and that could be a major U.S. corporation, but also for the buyer, a foreign corporation. So it's a commercial consideration of proprietary, why we don't publish that information and don't release it publicly. Nonetheless, public companies have to, U.S. public companies that are on the stock market have to do and report to the SEC in their filings that they're going through these processes, essentially because it's a major issue as part of the transaction and deal. Lastly, I just want to hit out the MLAT process. I think that's an interesting issue for people to really study. There's a number of MLATs that already exist out there. I think maybe more than 20. But reforming that process, I think, is extremely important. Companies like Google and the rest have seen that it has negatively impacted them because essentially it's a slow process. If you have a police officer in the UK that's investigating someone who is operating abroad in the United States, and they request through the US-UK MLAT that information be provided, they have to go to their authorities to make that request, and through the MLAT process, then go to the Justice Department in the United States, and that could take up to 6 months, 12 months. And by that time, you know how data and information flow and how people move quickly. You could have lost your entire case. So it's a very, at this point, a process that needs efficiencies and needs to be ironed out across the board. Google and other providers are hit by multiple requests at different varying levels for information by different governments. So they're looking for at least consistency. I mean, that's so important for companies that operate on a multilateral level. Consistency of operation, and so that's what they're building in the MLAT process. But some of the ideas out there, expanded geographic coverage, explicitly covering modes of communication associated with evolving networks, efficiency, transparency, which Obama has allowed recently, and inclusion of timetables for cooperated responses. The last thing I want to mention is the Microsoft case that's happening in Ireland. That's really interesting. A U.S. court, Southern Court in New York, has told Microsoft that it wants information off its servers in Ireland. Essentially, that's the extraterritoriality of information flows. Microsoft, with Google's and the Verizons, have sort of fought against it, and it's gone to, even though the lower court said that they had to give up the divulge the information, it's now in a federal court. So the final decision of where this goes will talk a lot about what the U.S. does in terms of its extraterritoriality of gaining information, since the information is on these Irish servers. And that will have a huge implication in terms of data localization, not only here in the United States and globally, but where that topic goes in commercial considerations. So, thank you.
I want to turn to Gary, but I have another question of fact before I go. It's my understanding, correct me if I'm wrong, is that the calls for updating CALEA go to the fact that what Google and Apple did with the iPhone is not covered under CALEA. So you can maybe get at them in other ways, but that act does not include the iPhone. Is that correct?
Yeah, that's correct, and that's an explosive issue. I mean, everyone wants their data and information to be protected, but there's legitimate arguments to say, I have an iPhone and I don't want my government being able to pry into that thing every time, anytime they want to. But there are due process considerations that I can still have. But you do have incident. I mean, in terms of the terrorists and those who wish to do harm, and they are out there. If you've not seen what ISIL is willing to do to innocent people, I mean, the threats to America happen every day. That's one of the benefits that I got when I worked in the National Security Council. For a period of time, I worked as the executive assistant to the temporary deputy national security advisor. I saw a lot of information of people who want to attack the United States all the time. The threat is real, and as much as privacy is hugely important, we cannot forget as Americans that the threat is very real. So, we need to balance it. We need to find an answer, and that will be a function of what we do in CALEA. But, the last thing we need to do is put people's lives in jeopardy. So.
There's a little silver button. Okay, thanks very much. Well, this is a really important piece of work, and you've all seen the Washington Post headline. The only problem with Ted's work is that because of these backdoors and so forth, you can't kind of shock people. And if we could, then the Washington Post would write about what you're doing. Maybe they will get around to writing about it anyway because it's extremely important. Let me step back to picking up on what Clay and Nova both said. This has, I think, quite enormous consequences. We may have reached the peak of globalization. And why do I say possibly? Well, trade has not been growing faster than GDP for 5 years now. And the trade to GDP ratio has been one of those measures of globalization. Also, direct investment to GDP growth, again, has been lagging. So the ratio of direct investment stock to trade to GDP is not growing faster, and that's another indicator. Everybody knows about the WTO having, difficult times. Maybe it's back in business with the TFA, Trade Facilitation Agreement, and the ITA. Maybe it isn't. We will see about the Trans-Pacific Partnership very soon, how that fares in the Congress. But it's fair to say that for almost 20 years, we've not had major trade negotiations. We've had modest trade negotiations, Korea, Colombia, and so forth. So that's kind of the big picture where I think we are seeing a slowdown in the pace of globalization. And then dropping down one level, if you look at the way protection comes in, it is sometimes or often through the national security portal. And it's widely recognized and has been historically since the time of Ricardo that there is a major national security exception to free trade. But that exception is often abused. So in this country, we have the Jones Act, which had its predecessor in a cabotage law dating in 1817. And the Jones Act is usually defended as a national security measure, although good studies done in various places, including...
This is the requirement to use U.S. shipping.
Oh, yeah, Jones Act. Oh, the people don't know that. Okay, I thought everybody knew about the Jones Act. You have to build the ship in the United States. You have to man it with U.S. personnel. And you must use that ship to travel between ports in the United States, port to port. So all the Gulf oil coming up to be refined in Philadelphia, for example, comes in these ships. And it is several times more expensive than using an international ship. Very expensive. It creates all sorts of distortions. It's a big barrier to U.S. negotiating of trade agreements, but it has a very strong lobby, and one element of that lobby is the national security argument, which has no foundation whatsoever. But it doesn't matter. Okay, but that's not the only kind of umbrella for protectionism, which is quite widespread. Another one is, what's the right food? Well, anybody who's followed the debate knows that hormones and genetically modified organisms, that's the European umbrella for protecting against U.S. agriculture. And it's a very effective umbrella. So we have these other arguments which are used. And in recent times, with the kind of global stagnation, we have had the the jobs argument, which again is completely misplaced, but we used it here for Buy America, and every appropriations bill going through Congress these days has a Buy America rider. And we are not the only ones. It's worldwide. Local content for every environmental project, every energy project, and so forth. There's a big thing, and that's been well documented. So this is springing up all over. So I know that's kind of a long introduction, but we have these headwinds to globalization, which has paid off very well over the last 60 years, but it's running into various headwinds, and what Ted has uncovered is a really big new headwind. Why? It's not the old trade, the trade that we know and love and learned in our high school and our college textbooks, which is at risk. That is, Ricardo wine for cloth. That's not going to be interrupted, nor U.S. exports of soybeans or what have you. But the big growth in trade going forward potentially is in services. See, now only a quarter of world trade is in services, but 3/4 of the population works in services. And thanks to digital technology, more and more services are now traded or could be traded internationally. And the barriers to services trade, even apart from what Ted has uncovered, are extremely high. They're as high as in agriculture, and there's data on our website and so forth. But, the typical tariff equivalent, as best we can measure it, starts at, say, 30, 40% and moves up to 100% very quickly. Ad valorem tariff equivalent on services trade, including U.S. isn't the worst, but we're bad, and other countries, China is terrible, and Japan is terrible, and so forth and so on. Well, this potential, it is at risk. And so it's the services trade and that stuff which is related to services trade. We've had this big information technology agreement, which was just kind of handshake in China a few weeks ago, and now it's being wrangled out in Geneva. Well, that covers all the stuff that we're talking about. So that's what's at risk, because protectionist arguments, which are mainly advocated by companies working through their governments, they can argue quite effectively, thanks to what Ted has talked about and what we know from Snowden and so forth and so on, that we need to protect this at home in order to avoid the 4 fears. This is a very powerful argument. You can state that very quickly, and the counter arguments to that take time to explain. So you don't have the sound bites on the other side of the argument. And it gets pretty deep into the goo pretty quickly. And I think the path ahead is exactly what Ted has talked about and Clay has talked about, Nova has talked about, is segmentation. This is the likely path. Now, what Ted has offered or recommended is an MLAT, a Multilateral Assistance Treaty, which would require some sort of, it would be symmetrical, and it would be some sort of process to symmetrically authorize wiretaps or insertion of back doors. See, that's all the equipment, is all the back doors. Well, I'm glad he's suggesting this. This may be a partial answer out of the segmentation which lies ahead of us. When Ted was in grammar school, I was running the tax program at the Treasury Department.
Oh, thank you, Gary.
And we have tax treaties, as he mentioned. This is a predecessor to this. The U.S. has long been very skeptical of giving foreign countries your tax data, or Claude's tax data. Claude's a very rich guy, no wonder. He'd have trouble every place he went, because so it's been a very slow process. And now I know there's all this talk about, inversions and so forth, and there's kind of a new push on exchange of information. But in the details, it's very hard. Why is it? The U.S., well, it's very much like what the question that Ted posed. The U.S. did not, for a number of years, want to give Mexico information on Mexican wealthy individuals who had investments here for fear that they would be persecuted in Mexico. And it was a legitimate fear. This was Mexico of a different era, but that fear is still very much alive when we talk about any exchange of information with China or, many other countries in the world. So with that precedent, and also money laundering has been a difficult path to get exchanged. Terrorism has gone a little quicker because of the generally felt threat of terrorism. But with that precedent, I think the MLAT, it is the way forward, but it will be a slow way, and it will start with our military allies. And you know who they are. They're the NATO countries, Japan, a very few others. And with those countries, possibly we can negotiate, we will have the degree of confidence, mutual, that we will be willing to agree that either we'll both put trapdoors or back doors in equipment, or neither of us will. And we'll both have intercept on digital, or neither of us will. So I think that's the likely path of the legal solution to the segmentation, which will mean a lot of countries are out of, or will segment. China will segment, is segmenting, will do more. Brazil will do more. Europe, that's a question. You'd think, we have many military allies in Europe, and you'd think we could probably negotiate with them. I don't know, because of the, popular reaction, which is so strong in Germany, which is a military ally. You'd think we could do it. So we shall see how it goes forward. I think in terms of research, which keeps some of us up here employed, 3 of us here, these 2 guys actually do real business. But in terms of, yeah, right. In terms of research, the big questions, the 2 big questions ahead, well, the big question is, how much will this segmentation cost? To get some real life examples of segmentation, and how fast it is proceeding, and what countries will be affected. I mean, even though, we may have problems with many countries in the world, and they don't trust us, so you can go to a lot of countries in that category. I'll take South Africa as just an example. But they don't have the resources really to have their own telecom industry. They're going to have to accept either Chinese or our stuff. It's all going to be backdoor act and so forth. So there are a lot of countries which will not probably segment because they're too small and can't. But the big markets, the big countries, and even the medium-sized ones may try to do that. And that's where it's very interesting to see how these costs develop and how quickly it slows down the globalization process, by which I mean removing existing barriers, because it's existing barriers. I'll stop with just one example, medical. Medical technology across borders is now, of course, a real-life possibility, including reading the x-rays, giving expert diagnosis, and so forth and so on. Well, that raises one of those fears that Clay raised. So is this going to be stopped or slowed down by what we're looking at now? Thank you.
Thank you. I'll just say one thing in passing we can come back to. I can see no chance that the United States in the foreseeable future or in any of our lifetimes is going to accept any restrictions on introduction of backdoors or malware. I mean, we start with that, but others may disagree with you. But I want to first turn to Ed and have you respond, and then we can get some colloquy among the 3 of the other 3 and you, and then we'll go to the audience.
I actually don't want to respond. I have found this very interesting, and I think all of the speakers have kind of broadened these concerns. I like Clay's 4 points. Nova's coverage and Gary's coverage, I think, were very good. The only disturbing part was Claude right now at the end. I kind of expected to come into this and have some, and maybe we have out in the audience, people saying what Nova said. You know, Al-Qaeda was nothing. Now we've got multiple more effective Al-Qaedas. This is really necessary. We have to do more of this. We have to have an MLAT that lets lots and lots of interchanges. We have to persuade the Germans to, you know, quit being so anti-Stasi. I mean, how can Germans not be anti-Stasi? But, you know, so I kind of thought this was going to be a shouting match, and instead we're all kind of worried but concerned and kind of realistic about this. But I'd like to turn to the audience and see where other people come.
Okay, is there any other comments back and forth of other things that other people have said, and then we can do that?
I would drop the word Stasi from your presentations from now on. It's a little provocative.
Okay. Is there any questions or comments from the audience? Here? I think we have do we have a mic here somewhere?
I'm Edward Williamson from Sullivan and Cromwell. I think this has been an incredibly interesting discussion of what is really a very, very complex issue. It seems to me that there are a couple of things that I was trying to figure out how to sort of get my mind around this, and in many ways, so Gary, certainly indicated the counterparts to, how this breeds, what we're talking about has a protectionist element in it, and I think all of us who've been in the foreign investment area have great concerns over CFIUS, whether CFIUS would turn into a protectionism instrument of a national policy and so forth. But then we're discussing the Microsoft case. We also see the same elements that we worry about in terms of extraterritorial application of sanctions, and so what we can do. So I guess where I sort of come out is that from the U.S. standpoint, we need to be focusing on basically the essential national security issues and make sure we are set on that. Then we ought to, as Gary again says, we ought to be getting our closest friends and most think-alike countries to join with us with standards. Ted sort of proposed the question of Russia and China and India. Well, if we do X, won't they do Y? Won't they do X also? And my response kind of is, aren't they already doing X or double X? So I think we probably shouldn't be getting into any kind of unilateral disarmament in this area, but I think we recognize that there's going to be very difficult issues getting other people to play by our rules, quite frankly.
The question, I have a couple of questions. One, just to pick up on the point you made about the Microsoft case in Ireland. If the U.S. courts uphold the government's position, which is, I think, it's going to be that should extend, how would the United States then defend itself or go against the Europeans now in an extraterritorial way? Say, okay, the right to be forgotten should be universal. It shouldn't be just in European servers. I don't know how you got to make up your mind about where the limits are nationally versus internationally. And it seems to me that in that case, you've got now. Admittedly, I should say, as far as I know, our government, and I've just written a piece saying they should have gotten into this more. Our government has not taken a position on the right to be forgotten. One person at a lower level or something has said something in Europe, I think. But that's a direct clash. What will be the consequences of that?
No, I think that's a great issue, and the right to be forgotten. Do Americans want the right to be forgotten? Well, look, I mean, once you put
I should say the right to be forgotten. For those of you who don't, not mavens of this, is that the European Court of Justice has said that if you see something on the internet and if it's either outdated or irrelevant or something of that nature, you can challenge it and say, we want that stripped from the internet. And Google, and then it's also been turned over to Google to handle this. A private company is doing, which is another problem, but we won't get to that. And so then they have recently said that this you can't just Google, you can't just take it down in Europe. You got to take it down all over the world. Sorry to interrupt it.
Does this apply to ex-wives?
Yes, it does. Yes, it does. Actually, go ahead.
Yeah, I don't think this is as much of an issue for sort of our generations as it is for sort of the internet generation that's going through it now. I mean, so much of their lives, and now in mine, is on Facebook or other sort of internet chat sites, and the whole cyberbullying, posting pictures and other issues. So I mean, it really is just a key discussion for the generation sort of after ours, Clay. I mean, that there's so much private information that people have posted and don't realize the consequence of it. I mean, should they have the right to say, take it down, especially false information? And, that's a debate that hasn't sort of crystallized here in the United States. But the issue of whether our ability of our U.S. courts to say, look, Microsoft, you have to provide that information, regardless of where the server is, because we are serving you the warrant of information, and you are in the United States, and ergo, it doesn't matter where you put it, you need to bring it back here. That has huge consequences, and it has consequence for European courts to say, well, our decision is the right for privacy and the right to be forgotten, and if that information, those pictures are on servers in the United States, they have to be brought down. So, that's a big issue. And the one thing I do want to also note is the Snowden opportunity. The fact that, it was seen what the U.S. was doing, and albeit with other governments supplying us that information, was that, companies take advantage of this. Companies say, what a great opportunity to tell my government that we can have a secure email and then we can build out from there. So, companies are out there looking for these opportunities, and they're looking for, the Defense Department does it all the time. We need to be secure, we need all this. So you need to purchase from us. That's where you get the Buy America stuff. You don't want to lose, and there's so many people who support it because there's so many U.S. companies who want to ensure they have a commercial advantage, and that's the nature of commerce. So,
Yeah, I think that will go to claim. I think that will happen. It's hard to get at how much the Snowden has really undercut, and it depends on the company. The example is often used is Cisco, which had its own problems, but Google has not suffered in Europe. It still has 80%. So it could, and you've had German and French companies saying, you should come to us because we can secure your data, and they cannot.
Let
So,
me
go ahead, and I'll come to Clay.
Let me
Sorry.
come back to another piece of history, which again, Ted was back in his grammar school days and has forgotten. But we've actually dealt with this issue in the antitrust area, because the U.S. at one time had a very expansive antitrust attempts with the global reach. And what other countries did would pass blocking statutes, and that's what we will get, is blocking statutes. I don't know if the Irish will pass one. They'd like to keep kind of friendly with the U.S., and so they may not do it to protect Microsoft. But the EU will. I mean, a big company like Germany will, China will, India will, and we will too. We're not going to allow some foreign country to come and tell whomever, I don't know, U.S. Steel or Microsoft or whatever, you've got to download all your stuff and deliver it to us. So there'll be a blocking statute, and then it'll be fought back and forth in the courts, and there'll be some kind of comedy decisions come out of that.
I'll turn to Clay. We also had a more recent example where the Europeans tried to extend a carbon tax for airlines, not just they were going to tax the airline, not just over Europe, but for the entire flight from, let's say, Japan to Brussels. And there was blocking United States Congress, but the Chinese, of course, they don't worry about the legal stuff. They just said, okay, that's fine, but we've ordered $14 billion worth of Airbuses. We're now talking to Boeing, and the Europeans back down. But anyway, go ahead.
Yeah, that issue got the United States and China on the same side for an occasion. Look, first of all, there are lots of extraterritorial applications of
various laws within the United States, by the way, in Europe and so forth. And this is where, in my opinion, this is why we have diplomats and why we have agencies that try to worry about the international implications of these issues, because I have no idea on what's going to happen on the Microsoft Irish case. I don't, or the right to be forgotten, or the example that Ted gave, which, if you think about it, is sort of a kind of, he's trying to give a provocative example, I think, of what if you have the Chinese version of Microsoft saying, well, I have a telecom server there. I want all that Facebook data because it's really important for back in China. How is the United States going to react to that? I will say the French Prime Minister, kind of to the point, just 2 days ago said, Europe must turn data protection into a competitive advantage. It's difficult to accept that European citizens have their data siphoned off by other countries without their knowledge. There is an argument, I think, within Europe, and I'm not going to say that it's the Prime Minister's argument, that there are companies within the United States that have actually gone into Europe, and it's almost like we are exploiting Europe. Our companies are exploiting Europe in the same way that in the 19th century, commodity companies were exploiting Africa. We're going to strip mine their resources, except for in this case, we're now strip mining their data and of their human beings. So these are very difficult issues. I thought your question was a very good one, which is there's clearly a national security nexus on some of these issues, and sometimes there really isn't. And that's where I think Ted points out the different laws that I would guess that 99% of Americans don't even barely know about exist. But a lot of Americans, and clearly a lot of Europeans, are very concerned about what is happening on all these different issues, but bringing that together at the same time trying to worry about, what does the FBI have to do? Are we against? Sometimes the FBI does have to go in and look at to try to stop a serial killer or something like that. They may look at telephone data. Are they going to be able to do that under some sort of encryption technologies? I have no idea. I just know that has been pointed out by literally the FBI director. So it's something that we have to think a lot about. And so I thought that Ted, at least by putting forward an MLAT proposal, is saying, this is how we can start trying to address this issue. I thought Gary made a very good point, but it isn't going to be quick. And so if anybody's looking for a quick solution, unfortunately, these are very, very difficult issues. And what I would suggest, and what I was trying to say in my points, is let's not come up with really bad policy ideas to try to respond to this. Let's try to kind of come up with sound ideas, knowing that we have different cultures about how we look at things, whether it's the United States or Europe, or, by the way, Asia's probably got a very different culture on these issues. So I was glad that I got invited to talk about these issues, but I don't have any great solutions either. So,
Do you have any other solutions or questions here? I'll go to the back, and then I'll come up here to the front.
Karen Riley from TOR. In discussions about MLATs introducing backdoors into systems, are cryptographers involved in these discussions? Because there are assertions from the information security community that inserting a backdoor is a vulnerability in an otherwise secure system to which access for allies only, excluding adversaries, cannot be controlled. And furthermore, things like public key encryption, they're already out of the bag. As Snowden has asserted, the math works. So if you want to have secure, reliable access for U.S. interests and their allies to the global internet, and in order to secure data and exchange information, the math either works or it doesn't. So at the point where you introduce legislation to make the math not work or to make endpoints less secure, that's going to hurt our interests. So where are the technical people in these discussions?
Great question. I have pondered this too, but I don't have the skill set to know. My inclination is, if you try and say, okay, we're going to build a backdoor that only allows NATO plus Israel and Japan to come in, but doesn't let anybody else come in, that anybody else people are going to be smarter than you and get around that. So I doubt that you can segment that access. Once you have capabilities of penetrating systems, the Chinese and the Russians and the Indians and others are going to be smarter than you and go around that. But that's that is from a guy who can barely handle, my own internet interactions. I'm not a technical guy.
And from a guy who can't even use an abacus, I do think that I think it's a question of timing, though. Again, none of us know, or at least I don't, and you don't, these guys may, what the NSA, which is really behind this, why they think it's still important, but they certainly would fight tooth and nail against the Congress, because House tried to pass something like this. In fact, it did, but it didn't go anywhere this past session. And I think what the NSA figures is that it is smarter, and it's a question of timing. It can introduce and use malware and then get out before others, or a backdoor before others can find it. And they very openly recruit geeks to do this in the system. There's no secret about that. The NSA does try to find some of the best minds in the colleges and universities, partly to see where these backdoors are coming from others, but partly to exploit them themselves. And I think that's what's its issue. I don't know whether that answers your question or not, but I'm guessing from external evidence that that's what's at issue. I think we had one more question here. She's right behind you.
Thanks. Peter Kosmala with the 4As. Thanks for your remarks today. This has been a terrific discussion. Just a quick observation for your comment and then an actual question. What's really intrigued me the most is this whole extraterritoriality issue that we've been talking about, and particularly with Europe, with right to be forgotten, their requirement that, for example, US-based companies, if they have overseas employees, in order to bring that data back to the US, that's subject to very special permissions and requirements. So it's essentially an effort on the Europeans to impose, their model of data protection on other jurisdictions, which I think is troubling. But I also think that that's informed by a very different social and cultural history than we've ever had in this country. I mean, you mentioned the Stasi in East Germany. There's other examples also in Romania, other places in Eastern Europe, in Latin America, in places like Chile, where there's been very oppressive government regimes and access to, without knowledge, to consumer or to citizen data. That's all very troubling and very legitimate. But I also think it underscores this notion of, could we possibly harmonize with that in any other way? I mean, in the data protection and the data privacy world, which is one of the policy issues I deal with, that's immensely difficult. There's been an attempt to sort of harmonize data privacy laws around the world, but that's just nigh on impossible. And it's sort of moved more toward a model of interoperability. Are there ways that we can make different aspects of these models work together? So I'm just curious if you're optimistic that in terms of the security context that we've been talking about, that's possible. And my specific question is, can you just elaborate further on the Dubai Ports World case, which I'm not familiar with, and I just want to understand the significance of that more. Thanks.
I can do Dubai Ports World really easy because it's really not all that relevant to the discussion we've had. I was just trying to point out how CFIUS had changed so much. So Dubai Ports World was it's a Dubai-based company. They do port operations. They have nothing to do with technology. It's port operations. They do them all over the world. They tried to buy something called P&O, which was a British company, actually, that had port operations on the eastern seaboard in the United States. Back in late 2005 to early 2006, Dubai Port World tried to buy those assets. There was a firestorm, huge press discussion, congressional inquiries, et cetera, from both Republicans and Democrats, all of it against the Bush administration for approving this transaction in CFIUS. And so in the end, what happened was, a bunch of different things happened. One is the Dubai company, frankly, had done nothing wrong, nothing, and is a very well-respected company around the world, had to back out of this transaction, or back out of the portion of the transaction that was about U.S. assets. For instance, they bought assets in Australia, nobody had a problem with that, or Canada, nobody had a problem with that. just the United States went crazy. And secondly, it changed. This is where the kind of more relevant to the discussion. It changed how we do CFIUS. Totally changed it. Like, we changed the law, we changed the regulations, we changed how we do things internally within the executive branch because it was such a, frankly, disaster. So I think that, but the only way it's relevant is that it kind of got everybody to start thinking a lot more about critical infrastructure and critical technology.
I think Clay left out the most important point. It was about penetration and surveillance, not electronic, but that somehow the Dubai ports would overlook either individuals, which is hard to figure out with U.S. immigration, or, you know, packages, cargo and terrorist-related cargo. So the way I would characterize it, it was the first time everybody thought of critical technology with penetration. But that quickly then led to Huawei, to, you know, other things where they said, oh, okay, same concern, critical technology penetration, but this is going to be for surveillance or disruption or, you know, bringing down infrastructure. I'm sorry, you explained the whole thing, but I think you left out the penetration word, which then
That's because it was a ridiculous argument. But I'm not saying Ted would agree with that. Just, it was at the time. It was just a totally bad political move.
A fine point on it, just to put a fine point on it.
Sure.
At the time, about 60% of the ports in the United States were operated and owned by foreign commercial actors. So I think it was just a miseducation. Also, by the way, only about less than 3% of the containers, you know, those box containers that come into the United States, are actually physically looked at. So the opportunity for a bad actor to put said dirty bomb or whatnot in one of those containers, let it go to the port, is there, no matter if it's foreign or U.S. The issue was, would it be more likely under United Arab Emirates, which, you know, we were doing a free trade agreement with them. We had our second biggest naval force in the world in their port as a staging operations for what we had to do in Afghanistan. And so they had boots on the ground with us as well. It was a hard time for a good ally.
But they're Arab. I mean, it got so nasty, you know, it really was just cultural. I totally agree with you. And in fact, they had a security arrangement which was pretty ironclad. We could go on and on about Dubai port. I agree it was a ridiculous thing.
Are there any other questions and comments? One larger point, though, about not Dubai, but about CFIUS, and this is a question for the two of you and Saban. I think one of the things that, at least to me so far, is heartening is that even with the explosion over Dubai and the Huawei, which wasn't so much CFIUS, it was the Commerce Department in the dead of night telling Sprint that it couldn't go along. But by and large, the CFIUS process has resisted going beyond the purely defense implications and getting into something about strategic industries. And the interesting thing here is that I've known it some years now, but other countries have a much broader similar process that really talks about national interest. The Canadians, I think, is in the public interest. In other words, their process would allow, and this is going to be, and this is certainly true in Europe, they'll allow intervention not just on fairly narrow defense or security, but on strategic industries that you think need to be economically competitive. And I'm always worried, but it hasn't happened, that we will start down that road, and there is always pressure in Congress to do that. And there's probably a bill up there right now that would do that. There always is. But that one heartening thing is that we haven't done that. And the process under Republicans and Democrats, under Obama, I don't think it's changed, have resisted that kind of broad thing. Is that correct?
Everything you just said is correct. The United States does CFIUS, which is just supposed to be purely national security. If you go to China, there are a list of industries in which frankly, if you're a foreign investor, you're not welcome. That doesn't really exist here in the United States. There's a couple of exceptions to that. If it is a national security issue, you will have a review. That review per Ted's points, is not really well known as to what's going on. A lot of that is by law, and Nova explained some of it is for proprietary reasons as well as classified information reasons. In Canada, they do have what is called a national interest test, which could get into economic issues. And yes, there is legislation existing right now that would basically try to expand that. Part of that is a fallout from a case that happened last year in CFIUS. If you didn't know Dubai Port World, just wait until you hear about this one, which was a Chinese company that wanted to buy Smithfield Hams in this country. Smithfield Hams basically runs pig farms, and
Very good
it's
ones.
a very good company, and there was a lot of concern about a Chinese entity taking over that company. It's hard to see the national security implications of raising pigs, and but that doesn't mean that there aren't some very important economic interests, and so that's why some people have said maybe we need to worry about economic interests. I, like Claude, think that that's a really bad idea, but that doesn't mean that it doesn't exist.
Well, I think we've gone over, and I think I'd like to end on that high culinary note of Smithfield Hams. So thank you very much. Enjoy it.